Okay, well, no problem at all. I just want to make a few housekeeping notes here before we get started. To allow the webinar to stay on schedule, everyone is muted. At the end of the webinar, there's going to be time for Q&A. For those participating via computer, note that there's a chat box that allows you to send messages to me or all of the attendees. If you have questions, please feel free to send them to me or the group in the chat box, and I'll answer them at the end of the webinar. For those participating via telephone, feel free to send me an email at jay@staffordtrialteam.com. That's JAY@staffordtrialteam.com if you have any questions. All right, so let's get started. Let me first start off by telling you a little bit about myself and my firm. Our firm focuses on employment litigation. We represent both employers and employees. We handle a wide range of employment-related matters, including wage and hour claims, sexual harassment, discrimination matters such as age, race, and national origin, disability discrimination. We also draft restrictive covenants for employers, which, as you will see in our presentation, include non-compete agreements, non-solicitation agreements, and confidentiality agreements. We also counsel employers on how to minimize their risk for employment-related actions. Although some business owners have never faced an employment-related lawsuit, we caution all business owners that this type of litigation is on the rise. Employees are becoming more cognizant of their rights, and there is a growing contingent of plaintiffs-focused lawyers ready to bring these types of lawsuits. We also represent businesses in business litigation and provide guidance on general corporate matters. We like to establish long-term relationships with our clients and often serve as outside general counsel to them. A typical outside general counsel arrangement that we have with our clients is a set monthly fee, which gives them unlimited telephone contact with us, and then a discounted hourly rate for our legal services. This is a great way for small to mid-sized businesses to cost-effectively build a relationship with us and to obtain immediate legal assistance. The more that we know about your business, the better able we are to identify issues and develop strategies to minimize any legal exposure your business might have. By way of background, I clerk for the Honorable Chief Judge Robert M. Bell on the Maryland Court of Appeals. I've been recognized as a rising star by Super Lawyers magazine and have also recently received a Martindale-Hubbell peer review rating. Our firm publishes a monthly e-newsletter that discusses various relevant legal topics. I'd encourage everyone to sign up for the newsletter on my website at www.staffordtrialteam.com. Today, we are going to talk about key contracts businesses should have, or at least consider having their employees sign. The entire goal in having employees sign the contracts that we're going to talk about today is to minimize the risk of employment litigation and to protect the business's proprietary information, such as client lists or technical data. While everyone knows that you cannot eliminate the risk of litigation, you certainly can take steps to put the company in a good position should litigation ensue. The first item that we will talk about today will be some general questions that all business owners should ask themselves. We are going to do a general self-assessment to find out where everyone is as it relates to employment contracts. The next part of the webinar, we're going to talk about 4 contracts that are key to establishing a solid employment relationship. The contracts that we will discuss are 1, the Atwill Employment contract, 2, confidentiality agreements, 3, non-compete agreements, and 4, non-solicitation agreements. We'll talk about the benefits of each of these contracts and how businesses can use them to protect the company and to set out clear guidelines to employees regarding proprietary and confidential information. Throughout the presentation, we'll talk about why these contracts are important. We'll also talk about an example. We'll also talk through an example of a business that utilized some of the contracts that we are going to discuss and reflect on some lessons that we can learn and action steps that business owners can take now to protect their company. We'll close with a brief opportunity for everyone to ask questions. In today's economy, we have to acknowledge that many businesses are in the service industry. Because of that fact, a key component of many businesses is information. The question for many businesses is, how do your employees interact with that key information that you use to differentiate yourself from your competitors? If you are a business in a service industry, you have to have contracts in place with your employees to protect your business's currency, which is information. And thinking about what types of contracts your company may need, every business should ask themselves the following questions. What does your business do now, and where is it going? What do you envision your company doing in the future? Which of your employees have access to critical information that is essential to the success of your business? For example, client lists, formulas, market data, or any other type of information or knowledge that is essential to the success of your business. Another question that every business owner should ask is, what systems does your business have in place to monitor and control access to that information? In an age where employees are constantly shifting to different employers after short periods of time, every business owner needs to ask, do I have the systems in place to enforce the covenants that my employees execute? So along those same lines, if my employees have entered into an restrictive covenant prior to joining my company, do I have systems in place to deal with the restrictions that the employee is subject to once they join my company? We're going to start off by taking a quick sort of survey here. One second. Like those participating to you can participate in the survey in two ways. One, you can go to the website, poll, let me highlight this. You can go to this website that's indicated here and participate in the poll. Or you can text, follow the text guidelines there to participate. So this poll wants to find out, what contracts do you have your employees sign before you hire them? For instance, do you have your employees sign an Atwill Employment Agreement? Do you have your new employees sign non-compete agreements or confidentiality agreements or non-solicitation agreements? Some companies have their new hires sign all of the above, and some have their new hires sign none of the above. So I'd definitely love it if you could participate in the poll and just sort of give us some insight into what your new hires are required to sign before joining your company. I'll give you a few minutes to participate. All right. Well, all right. It looks like the common answer here is none of the above. Well, we're going to talk through the reasons why these restrictive covenants are important. One second here. All right, so let's keep moving through the presentation. Essential contracts to minimize litigation risk. And thinking about these 4 contracts that we're going to talk about today, it's important to think about these contracts or covenants as pieces to building a solid employment relationship. When all of these pieces are working together, your company is taking important steps to protect its proprietary information from its competitors and minimizing the risk of employment litigation. This is where business owners should strive to be in terms of their employment relationship with their employees. The Atwill Employment contract is the very first piece of the puzzle in minimizing the risk of employment litigation. Everyone that lives in Maryland and DC is typically aware of the general rule that an employer can terminate an employee for just about any reason or no reason. This is known as Atwill Employment. Because of this general rule, many small to mid-sized businesses do not think it is essential to memorialize the Atwill Employment relationship. This is a mistake. Many businesses do not realize that failing to memorialize the Atwill Employment relationship leaves the business vulnerable to litigation. So why would you want to make an employee sign a contract making it clear that their employment is at will? Well, for a few reasons. One, if an employee makes an allegation that the employment relationship was anything but at will, you want to have a document signed by the employee refuting that assertion. Secondly, you cannot be sure what was said during the hiring process or even while the employee was working at the company. For example, what if your hiring manager said something like this, quote unquote, "You'll always have a place here as long as you keep up the great work." Or what if a supervisor said, quote, "We'll give you a year to learn the ropes." You want the signed Atwill Employment Agreement so you can have a document signed by the employee to reject any assertion that the employment relationship was anything other than at will. All right. Another contract that you want to have employees sign is a confidentiality or non-disclosure agreement. In today's business world, we have a lot of Edward Snowdens running around who have a desire to share everything that they know. A confidentiality or non-disclosure agreement makes clear to the employee what information the company considers confidential and makes clear to the employee that there could be significant consequences if they disclose information designated as confidential by the company. To effectively put together a confidentiality or non-disclosure agreement, the company has to seriously think about what information it believes is confidential. In turn, it has to communicate that to its employees. A part of that communication process is requiring employees to sign confidentiality or non-disclosure agreements. The company, in addition to having employees sign these agreements, should also put systems in place to keep the designated information confidential and regularly update those systems to deal with any changes that might have taken place. The confidentiality agreement gives the company a basis for its asserting in court that it took steps to keep certain information confidential. A non-solicitation agreement. This agreement precludes a former employee, for instance, from reaching out to the company's clients or employees in an effort to recruit them to join the employee's new company. In service businesses such as financial planning or sales departments where one-on-one relationships are critical, non-solicitation agreements are important. These agreements prohibit a former employee from actively soliciting your clients or current employees. A key thing to keep in mind, as with all of these restrictive covenants, is enforceability is an issue. From a practical perspective, if you are running a business where you have client lists, in addition to requiring the employee to enter into a non-solicitation agreement, you'll want to also put in place a system that monitors or controls access to that client list. These agreements can be crafted broadly or narrowly, and also can have significant recourse provisions, such as clawback provisions or forfeiture provisions that can be quite expensive to an employee who violates the agreement. A non-compete agreement. Another important contract that employers often require employees to sign is a non-compete. These agreements, if done correctly, can preclude the employee from competing directly with your company or from joining another company that directly competes with yours. As you might suspect, the courts cast a very critical eye towards these agreements because they limit the employability of individuals, which gives rise to a public policy issue. In thinking about non-compete agreements, businesses have to be very careful about who they require to sign these agreements. You ordinarily should only require those employees who have access to sensitive information or key relationships to sign non-compete agreements, or for that matter, the other restrictive covenants that we discussed today. The types of employees we're talking about here are managers, high-level executives, or your sales employees, or those that deal with sort of proprietary information. As with anything, there are exceptions. It all depends on the nature of your business. Be rest assured, however, that the court will be looking at all of this and evaluating the enforceability of the non-compete agreement should you decide to have your employees sign one. In crafting a non-compete agreement, the court also will look at whether the restriction is reasonable in terms of time and geographic scope. As a business, you have to be able to articulate why the geographic scope and duration of the non-compete is reasonable in light of the employee's relationship with clients or knowledge of certain business information. Each business has to think through these questions because that will inform how the non-compete is crafted. As a general rule, 2 years after termination of employment is about the upper limit of the reasonable duration of a non-compete agreement. Likewise, the geographic scope of the restriction must be as limited as possible to avoid a finding of unenforceability. Another key issue every business owner has to think about and ensure occurs, another key issue every business owner has to think about regards consideration. In order for the non-compete agreement to be enforceable, the employee has to receive consideration for entering into the agreement. Because at the heart of these agreements, of all the agreements that we've talked about today, they are contracts. So what's that mean? That means if the employee has not yet been hired, courts typically will view the hiring of the employee as consideration for entering into, for instance, the non-compete agreement. However, if the employee is already at the company, continued employment at the company is often not considered adequate consideration to make the non-compete agreement enforceable. Excuse me. So what we recommend is that if you have an employee who's currently working at your company and you desire to have them sign a restrictive covenant such as a non-compete agreement or a non-solicitation agreement, it's important that you offer that employee consideration. And we recommend things such as a bonus, a pay raise, or additional stock options. And we also recommend that within the agreement itself that you specifically articulate the consideration that you provided to the employee. This way, there is no question that consideration was given to the employee for entering into the covenant. And this helps ensure that the court won't strike down your agreement. No business owner should try to draft one of these agreements themselves. If you want to have an enforceable non-compete, it is absolutely essential that it be drafted and executed correctly. In thinking about non-compete agreements or any other type of restrictive covenant, you have to think about whether you have the right systems in place to enforce the non-compete. For example, do you conduct exit interviews to find out where the employee is going to work? So if the employee is leaving your company, do you sit them down and ask them where are they going to, obtain new employment? Do you remind the employee that they are subject to a restrictive covenant? Also, do you notify the departing employee's new employer that their new employee is subject to this restrictive covenant? Similarly, does your company have systems in place to deal with new employees that you hire who are subject to restrictive covenants? For example, do you instruct new employees in writing that they are to abide by their restrictive covenant from their former employer? Do you monitor the new employee to ensure that they are abiding by the terms of their restrictive covenant from their former employer? So let's talk about the why. There are a multitude of reasons why you would want to have your employees sign one of these agreements. Some of these reasons are obvious, but others are not so much. One of the reasons why you might want your employees to sign one of these agreements is that it could enhance the value of your company if you decide to sell it someday. One of the first things that any business looks for when it is acquiring another business are the contracts that it has. When a potential buyer sees that a company that it is acquiring has these agreements in place, it enhances the value of the company to be purchased because the purchasing company has a level of assurance that its purchase of clients or information will be protected under these agreements. In short, the company doesn't have to worry about an entire department walking out and taking clients. Another reason you might want your employees to sign one of these agreements is that it clarifies expectations of your employees. It makes clear to your employees, among other things, the expectations that the company has as it relates to the confidentiality of certain proprietary and important information, as well as the company's expectations regarding whether the solicitation of clients and current employees upon departure from the company will be tolerated. Finally, these agreements make competitors think twice about poaching your employees. These agreements, as well as the proper enforcement of the agreements, send a clear message to your competitors that if they do successfully recruit one of your employees to their company, assuming that the employee isn't under a non-compete agreement, that employee is going to be very restricted in what they can do at the new company for a period of time. So let's talk through an example here. This is a real case, and this just sort of highlights a few things. One, it highlights the importance of the agreement, and it highlights the potential consequences that can give rise if an employee violates the agreement, and if the new employer who hires the employee sort of is complicit in the employee's violation of one of these restrictive covenants. So let's take a quick look at this fact pattern. Suppose you have employees working at an insurance brokerage agency who are subject to a non-solicitation agreement. For those who are not familiar with the insurance brokerage industry, it is very much a relationship-driven business, almost like financial advisors. That group of employees decides to join a competing insurance brokerage agency. And leaving the company, some employees take trade secret and confidential information to the competing agency. The insurance agency from which the departing employees are leaving informs the competing insurance agency that each of the departing employees is subject to a non-solicitation agreement. After joining the competing insurance agency, however, the new employees begin to solicit clients and former colleagues. In this case, the court awarded $4.5 million in punitive damages to the insurance agency from which the departing employees left. This $4.5 million punitive judgment was entered against the departing employees and the competing insurance agency. So, what lessons can we learn from this example? The first lesson that we can take away from our example is that businesses must not only draft these restrictive covenants, but they also must have a mechanism in place to enforce them. In our example, the insurance agency from which the employees were leaving had not only the agreements in place, but the enforcement mechanism in place. This is critical because as a business, you want to not only remind your departing employee about the restrictive covenant, but you also want to put the new employer on notice so that you can seek damages against the new employer and probably has deeper pockets than your former employee. We also can take away from our example the importance of monitoring and controlling who has access to sensitive and proprietary information. Here it looks like the initial insurance agency had a system to monitor access, but it's not clear about how effective the control mechanisms were. Regardless, as a business, you want to have both the ability to monitor and to limit access. It is very compelling at trial if you as a business can say unequivocally to the court that your former employee, right before leaving, accessed proprietary information and took it with them. Another big lesson we can learn here is that employers who hire employees subject to these restrictive covenants should be sure to get a signed copy of the restrictive covenant that the employee is subject to. In addition, the new company should direct every new hire in writing who's subject to a restrictive covenant to abide by the terms of the restrictive covenant that they entered into with their former employer. By the business communicating this in writing to the new hire, you have a document that you can hold up that makes clear that you as the new employer were not complicit in the employee's violation of the restrictive covenant. So what action steps can businesses take? So now that we've talked about the importance of these agreements, what steps should you take going forward? The first step is that every business needs to do an internal review and figure out which agreements make sense for their business. And don't just think of what makes sense now, but also think about whether your business is planning on engaging in activities down the road where it would make sense for you to have certain employees enter into restrictive covenants. It is important to recognize that these agreements are not do-it-yourself agreements. I'd caution anyone who is thinking about trying to draft one of these agreements on their own to think twice about doing so. These agreements are important and must be done correctly, so engage legal counsel. We can think through other mechanisms that you should be putting in place to enforce restrictive covenants. Without an enforcement mechanism, the agreements aren't worth the paper they're written on, and vice versa. If the agreement is unenforceable because it wasn't drafted or entered into appropriately, it isn't worth anything to the business. So contact us so that we can begin working with you to draft these important agreements. Before we get to questions, I'd encourage everyone to go to our website, www.staffordtrialteam, and to sign up for our newsletter, which goes out once a month. Likewise, while you're on our website, please follow our firm on social media by clicking on the social media icons on the top right-hand corner of the home page. And if you scroll down, you can sign up for our newsletter here. We also have a free resource for business owners that we think will be helpful to you. We encourage you to download it. It's 5 essential contracts to help your business avoid legal pitfalls. So with that being said, one second here. With that being said, we'll open the line up to any questions. Please feel free to send me a question in the chat box if you have it, or if all else fails, please feel free to send me a question via email at j@staffordtrialteam.com. I'll give you a few minutes to send me questions here. All right. Well, it looks like there are no questions. I hope that everyone found the presentation to be informative. I'm going to be sending a survey out in the coming days to get feedback. We plan on doing a webinar once every quarter, so please be on the lookout for the next webinar date and topic. Signing up for our e-newsletters are a great way to make sure you don't miss the next webinar. I want to thank everyone for their time, and I look forward to reaching out to everyone in the next few days. Thanks so much. Bye.